Morning, everyone. Thank you very much for that. My name's Harry Ellis. I'm a partner in the Financial Regulatory Group at Linklaters. I've got a couple of people who are going to come and share the stage, and we're going to do a bit of a Q&A for you on the regulatory aspects. So if you could welcome up Gary Chu from UBS and Stuart Davis, a Managing Associate at Linklaters. So thank you very much for having us today. It looks like we've increased the tie quotient by at least two in this room. So what we're going to cover today is just a few sort of thoughts around the regulatory environment on blockchain. So just a couple of sort of early observations to help set the scene. Blockchain itself is not regulated in a financial services construct. But clearly, the financial services industry is very, very well regulated. You've got, if you are generally speaking carrying out a regulated activity such as buying and selling securities, running a CCP, giving advice, those sorts of things in relation to financial instruments, then you'll need to be a regulated entity. So while blockchain itself is not regulated, if you are using blockchain for some form of regulated activity, then that could easily bring you within the regulatory scope. So these are the sorts of issues that we're going to be sort of teasing out today around what is subject to the regulatory scope and how the regulators are dealing with that. So the first thing I'm just going to ask is, Gary, if you could sort of tell us a little bit about what you're doing at UBS and how you're looking at some of these issues.
Yeah, sure. So at UBS, we established an innovation lab at Level 39 Canary Wharf just over a year ago. A very deliberate decision was made by the bank to set up our lab at the FinTech Hub at Level 39, away from the main business headquarters in London. It doesn't mean, though, that we've been busy just writing code and running proof of concepts. There's been very much a big focus on ensuring that we're very closely engaged with the various business lines, so in the investment bank, wealth management, asset management, to really understand how blockchain can be used to enhance and streamline existing processes, to underpin new business models, and to apply that understanding in practice. We've also been outward-looking, so we have struck up a number of collaborations with other banks and also startups. Legal and compliance considerations are very much front and centre, so we're maintaining dialogue with central banks and regulators, and we're also talking to external legal advisors like Linklaters to help us navigate the associated hurdles.
And Gary, you talk about some of those associated hurdles. So what is it that you're seeing as the barriers to your development of blockchain technology from the bank's perspective?
Okay, so I'm going to speak more generally from a broader perspective. I think at UBS we think there are three basic ingredients needed for success in this area. I think the first thing is we need very good plumbing. So let me sort of explain that. So it's widely acknowledged that there's real great potential with blockchain technology and the benefits it can unleash for the banking sector. But I think to realise that potential, what the market needs is a new common market fabric based on distributed ledger technology, forming the backbone infrastructure of plumbing to provide the basis for the development and eventual maturing of the various blockchain use cases and applications. So to give an example, one of the projects that we've been working on at UBS is the idea of a common system for the transfer of value, so a payment system, which we call the utility settlement coin. It's a concept that we've been exploring with a startup, Clearmatic, since last year, and we're continuing to collaborate with other players in the market. But the idea behind the utility settlement coin is simply this. We at UBS might have a platform for issuance and trading of bonds based on blockchain. On the other hand, we might have Morgan Stanley with another similar platform for trading in securities. But to achieve settlement finality, we need the two systems to talk to each other, to plug into a common system for the transfer of value for settlement of payments. So we see common market fabric elements like that, along with digital identity, as very, very important. And that's the first essential ingredient that we think we need for the development of blockchain. The second thing is we see the need for favourable economic conditions. It's not a lot that we can do about that. We certainly want more certainty in the market. There's at present quite a cost-cutting culture within a number of banks, including UBS. So I think what we're trying to do is for the economic conditions to play out such that there is a greater incentive to invest in emerging technologies such as blockchain. And then finally, I think what we need, and this is speaking like a true lawyer, I think we need a supportive legal and regulatory environment that really enables, rather than stifle fintech innovation.
So one of the things you said there, Gary, was around settlement finality. So just to explain that, in the financial services industry, if you're buying and selling securities, you need to know exactly when that sale goes through and when the money is received, and that is known as settlement finality. And generally speaking, from a legal perspective, you need that to be done by a regulated CCP or some other platform which is in the regulated sphere. So it seems, it just goes back to what I was saying before, which is while blockchain is not regulated, a lot of the players in the financial services industry clearly are regulated. So that seems to give those people, such as UBS, a bit of a head start. So, Stuart, just turning to what regulators are looking, and are they doing enough to support blockchain, particularly in the use by blockchain of non-regulated entities?
Sure. So I think the regulators are trying to balance two competing objectives. The first is consumer protection and ensuring that real value isn't lost through adopting a blockchain system. And the second is ensuring that London remains a sort of global fintech hub or becomes a world leader. There are a couple of things that the FCA in particular has done to support fintech. The first was its FCA Project Innovate, which many of you will have heard of or may be a part of, and that's essentially a specialist team within the FCA aimed at assisting firms, particularly startups, to understand the key regulatory issues around fintech, blockchain, and understand if they do need to be regulated, what are the ways in which they need to go about that. The second step was the Regulatory Sandbox. That is a safe space within the regulatory sphere in which firms can test new ideas without necessarily being regulated, and the FCA will give what it calls a letter of no enforcement. So if in testing your new products you trip a regulatory prohibition, the regulator won't enforce against you. Now, to play in the sandbox, there are a number of restrictions. For example, you have to limit the number of customers that any product would be distributed to around 150. So it's not going out to the market without being regulated, but it does enable you and the regulator to understand whether there are any risks with novel technology. The FCA yesterday, I think, also put out a call for input on RegTech, and it says that RegTech is the fastest growing of the FCA's priorities this year. The Treasury's also published an innovation plan for financial services, and it's looking at are there regulatory barriers which are preventing competition and innovation in this space, and looking to try and reduce some of those regulatory barriers. One of the key things which has come out of that is the concept of international fintech bridges, which aim to allow UK fintechs to expand internationally into different jurisdictions. But one final point I'd make, so there is a lot of UK regulatory sort of innovation in itself happening, but one point I would make is that there's significant restrictions on what the UK regulators can do in terms of, say, deregulation. because most of securities law, which applies to fintech, is governed at a European level. So the FCA has limited scope to actually deregulate. It would need to lobby in Europe. And I'm not at this stage going to mention the impact of Brexit, but we might come on to that later.
And underlying all of these sort of innovations, what do you think the key concerns of the regulators are going to be around potentially making it easier for participants to enter into the market?
So I think there are probably 4 key concerns. The first I've already mentioned, which is consumer protection. The FCA has a statutory objective to protect consumers in relation to new innovations. I think the second is, does the blockchain system create a regulatory lacuna where the regulators can't actually regulate all participants? Gary mentioned that the piping which sits behind blockchain, and because that operates on a distributed basis, it's possible that, say, the UK regulators, may not be able to regulate the people who control the pipes because they might be based anywhere in the world. So I think there's a worry there. There's also a worry around the resilience of any new technology and whether that can lead to consumer detriment. And we'll come on to some of the ways in which the Bank of England is looking at testing that resilience. And also the key concern is whether blockchain could lead to financial crime and terrorist financing. And if there is a regulatory gap, are there lax systems and controls inbuilt within the system that mean that that those sort of nefarious activities are allowed or actually even encouraged?
So Stuart, you mentioned about the Bank of England PRA, so we talked a bit about what the FCA's concerns are. What is the Bank of England's thoughts around this?
So I think the Bank of England was a little bit slower than the FCA to sort of get involved in the blockchain space. But earlier this year it's announced a fintech accelerator, and the purpose of that is to engage a number of firms, whether it be startups or incumbent banks, to test various blockchain use cases and to be able to enable the bank to understand some of the risks and also opportunities around blockchain. And I think one of the key opportunities the bank, one of the key advantages the bank found is that blockchain removes the single point of failure from the financial system that's currently there, because at the moment you have a number of intermediaries, each performing different functions and reconciling books and records between each other. But if one of those players in the system fails, there could be real issues in terms of reconciliations. So they built a sort of multi-scalable blockchain system, and they tested smart contracts as a use case on that blockchain system. And they found that there are 4 areas where they have concerns. The first is the system truly scalable? And I think they were looking at, is it scalable to replace effectively the financial security settlement and trading operations that currently go on? Is the system secure? And particularly in terms of protecting privacy and data, whether the system is resilient enough, and also whether there's interoperability of the system. So if you think about it, it's unlikely that there's going to be a single blockchain ledger that emerges. There's likely to be hundreds, if not thousands, of competing ledgers emerging in the future. And how does that interlink with the need for the financial services system to be interoperable? How can securities that are traded on one system and recorded on one system move across to a new system? Do we need common protocols in order to achieve that?
And Gary, are you seeing, Stuart mentioned about interoperability between the blockchains. Is that something that's of interest to UBS? Are you trying to sort of work through how that is, or are you just quite siloed at the moment?
No, the thing is, I think we're very much focused on the topic of interoperability because, and I think there's sort of two sides to the question, because I think there's a computer science problem. So the idea that, you know, can a blockchain based on Bitcoin, on the Bitcoin network, talk to a blockchain created on the Ethereum network? Now, that I think currently at the moment, I think efforts are being made in the world of technologists to work through those issues. So I think further focus is being put onto that. But I think there's also a question of interoperability from the perspective of if different bank blockchains are plugging into the same plumbing, we need to make sure that there are common sort of technical standards. And in setting those standards, there is also a legal piece in that, because we want to make sure that the standards that are set are based on objective, justifiable criteria, and they're not going to be in some way anti-competitive, intended to sort of, you know, block out certain competitors.
And I think the regulator, again, looking at the resilience point, will be focusing on whether if a ledger were to fail, can the securities and the coins sitting on that ledger transfer easily over another ledger so that consumers aren't impacted and, you know, investors aren't impacted as well.
So let's turn back to sort of where we started. This was around regulation and asking ourselves a question as around whether blockchain can itself effectively be regulated, and the answer to that is a bit yes and no. I mean, clearly you can regulate the people who provide blockchain, which, if you're looking at a permissioned ledger system, is simply a matter of imposing that regulatory obligation on the proprietor. But it's a little bit more difficult when you have an unpermissioned system like Bitcoin, where you may not have someone who you can easily identify as the proprietor. And while the FCA has been very keen to go out and enforce against people who they think are undertaking regulated activities without permissions, you have lots of these. There was a recent case around land banks, for example. If you can't actually identify the person who is actually controlling the system, how can that enforcement action be brought? So certainly to date, where they've been coming out is clearly if it is run by a UBS, for example, or a regulated someone who's already in the regulatory sphere, then it will come within their scope of regulation. But if not, something like Bitcoin it sits outside of the regulatory scope. It's not a currency. It's not a regulated asset, as it were, a regulated financial instrument. Where the regulators have gone to date is to regulate some of the people who interact with Bitcoin, so some of the payment service providers and things along those lines. So it's a moving feast at the moment, and it sort of raises a question as to whether we need new legislation to facilitate blockchain and innovation in this particular sector. And while you may see this as annoying competition, Gary, I was wondering if you had a view from UBS's perspective as to what that sort of new legislation might look like.
Yeah, so I think on that topic, I think there are probably complex public policy decisions to be made by government. I think that the sense that we're getting from conversations with regulators and central banks is that there's probably a general reluctance to regulate specific forms of technology, because then it sort of turns out to be a bit of an arms race. So new technology, you need to catch up and enact new laws. But I think if you think about the current raft, the huge raft of legislation that we've got regulating the banking sector, I mean, the list really goes on. There's MiFID, there's EMIR, CSD. All of that existing framework exists to protect consumers, to ensure market stability, to ensure that the financial sector works for everybody. So I think it's probably a matter of time before we see legislative and regulatory change. but it could take a while to come through. And I think a lot of the banking sector regulation at the moment is not specific to a particular form of technology. So I think it comes back to your point, Harry, about whether or not you're using blockchain to engage in a regulated form of activity. So I think until we see the new legislation, players in this space will just need to think about the existing framework and how it applies to them.
I think at the European level as well, which is where at the moment we would need to see regulatory change stemming from. ESMA has recently released a sort of call for input from the industry. And the sense I get from that is that regulators are still trying to understand both what the technology does and what some of the use cases are in particular. And ESMA has said that they're going to take the responses to that call for input and they're going to develop their own policy on blockchain, which I think is interesting that they've admitted they don't currently have a policy on blockchain. But once they've developed that policy, they've said that they may look at whether a regulatory response is required in relation to blockchain. Not clear whether that means increased regulation or regulating blockchain specifically or decreasing regulation.
So one of the things is if you're an unregulated entity at the moment and you're potentially straying, your use of blockchain is potentially straying into the regulatory sphere, do we think that the regulators are going to be keen to be taking enforcement action? Gary, do you have a sense of that?
Yeah, I mean, we've been watching the space quite carefully at UBS. I think in this country, there's been no major enforcement action in this area as yet. But I think it's inevitable because, bad things happen to good people. Despite best endeavours, we slip up and mistakes are made. So it's sort of interesting to note, though, that in the US there has been enforcement activity in this area. So you may have read about Ripple being fined $700,000 by the US authorities. So the Financial Crimes Enforcement Network took action against Ripple and established that they had broken requirements under the bank secrecy law in the States. So what Ripple was found to have done wrong was they failed to register as a money services business under the US framework, and also they didn't maintain an anti-money laundering program. So I think it's certainly an area that we need to be sort of watching carefully, because there are clearly negative implications for the players involved. So fines and reputational damage, but there's also potential risk of individual liability. So that means fines for senior management involved and potentially imprisonment in severe cases.
Excellent. And so just one final question, I think. We've talked a lot about what's happening in the UK and to a lesser extent what's been happening in Europe. Stuart, what are we seeing internationally with the interaction with other regulators around the world?
As I mentioned earlier, fintech bridges, this concept of a fintech bridge. The UK has recently established one with Singapore. And this is where the regulatory authorities will talk to a startup, see where it wants to expand globally, and it will actually refer the startup to its sister regulators across the world. So there's a bridge between the UK and Singapore at the moment. There's also one in place with ASIC in Australia. That's obviously sort of in line with the export Britain mentality at the moment, that we need to try and develop our own sort of expanding big fintech startups. So that's one key way in which the regulators are looking internationally outwards. In terms of what other regulators are doing, there are a number of regulators across the world who are looking to try and gain a march on the UK authorities. And what they're doing is looking at what the FCA has done, which has gone down very well worldwide in terms of the innovation hub and the sandbox. They're replicating that, but they're tweaking it for their own jurisdictions, and also finding areas of sort of tension within what the FCA has done and trying to remove those. Speaking to my colleagues in Singapore, it's quite interesting because they say that the MAS, the regulator in Singapore, has an easier job than the FCA because it isn't subject to European legislation. So it can actually waive its own requirements in securities law, whereas the FCA can't do that at the moment. So it is possible that we'll see Singapore, I've heard Frankfurt, Berlin emerging as fintech hubs, and obviously San Fran as well.
Excellent. Okay, well, thank you very much. I think we'll wrap up there, and hopefully that's given you a bit of an idea as to some of the regulatory challenges that people in the blockchain space face at the moment, and how some of them may be alleviated at some point in the future. I'd just like to thank my two colleagues up here, Gary and Stuart, and thank you very much for listening.
Ladies and gentlemen, put your hands together for Gary, Stuart, and naturally our moderator, Harry, as well.